The Supreme Court heard arguments Wednesday in a redistricting case that could have historic implications for future elections. Republicans in Maryland are challenging the state's congressional district map, and they say Democrats drew it to intentionally favor their own candidates and force out an incumbent Republican. Thomas Wolfe is counsel at the Brennan Center for Justice, and he joins me now from Washington. Thomas, thank you for joining us.
Thanks for having me on, DeMarco.
All right, the plaintiffs in this case say Maryland Democrats' gerrymandering efforts violate their First Amendment rights. What are the main points they are using to make this case?
Well, what the Republican challengers are arguing in this case is that for a long time they had the opportunity to elect a candidate of their choice, a Republican member of Congress. Democrats in 2011, who controlled the redistricting process, decided that they didn't like the fact that Republicans were able to elect their candidate. And so what they did when they redrew the districts in 2011 was take out a large number of Republicans and replace them with Democrats. What that meant was the 6th district, which had been reliably Republican, became a Democratic district. This particular issue with the 6th district that the plaintiffs are complaining about is part of a bigger pattern in 2011 in Maryland, where the Democratic map drawers tried to create what's called an extreme partisan gerrymander. Up to 2011, they had 6 seats out of Maryland's 8, and they decided that they wanted to expand their hold to 7 seats. So they flipped the 6th district to get the 7th seat.
All right, let's go ahead and talk about Attorney Michael Kimberly, who is representing the 7 Republican voters from Maryland's 6th district. He was asked Wednesday what he wants the court to decide, given that midterm elections are only months away. Here's some of what he had to say.
We're looking for is the court to clarify to the district court what sorts of standards ought to apply as we move forward to trial. We think the time is now for the court to clarify for us as the litigants and the lawyers, and also for the judges who've got to decide this case in the district court, how they should go about doing this.
All right, Thomas, can you break down his answer in terms of what the Supreme Court can ultimately adjudicate here?
Right. So what the Supreme Court is trying to do is basically come up with a standard that can govern these kinds of cases. We know coming out of the argument that there is a majority vote on the court right now that there's something unconstitutionally wrong with Maryland's map. We also know that there's a large block on the court that thinks that extreme partisan gerrymandering is a concrete problem that is very serious, that's recurring throughout the country, and needs a legal solution from the court. We also know, based on things that Justice Sotomayor said and Justice Kagan said, that when you have an extreme partisan gerrymander, the kinds of problems that the courts have faced in the past dealing with these issues, figuring out how much partisanship in map drawing is too much, basically isn't an issue because things are so extreme. So what the court needs to figure out, and what it seems to really be working through in this case and the preceding case from Wisconsin, is how to take a big enough bite out of the problem of gerrymandering that they can be confident their decision is going to make a difference, but also make sure that they don't reach so broadly that they get involved in too many cases.
Thomas, we should also point out that the Supreme Court has never struck down a district map due to partisan gerrymandering. Could that precedent influence what they decide in this case?
You're correct that the court, in the many decades that it's dealt with these issues, has never struck down a map for being unconstitutional. However, there are a couple of important key developments. Those precedents come from about the mid-2000s. Even then, a majority of the court agreed that extreme partisan gerrymandering is unconstitutional. The question was basically, how can we tell when it's happened and when is it too much? In the intervening time period, we've seen substantial developments in social science that's helped us identify extreme maps, but also because the court hasn't taken action in the past, maps have gotten more extreme. Legislators are basically pushing their advantage because they haven't been given a red light by the court. And the result is maps have gotten out of control, and we end up with maps like we have in Maryland and maps that we have in Wisconsin that are clearly on their face extreme. Once we're in that territory, the legal question becomes easier. So I don't think the prior hurdles that the court has faced are necessarily going to be as much of an issue this time around.
So can you explain the broader significance if that type of gerrymandering is no longer allowed?
Right. So, one of the debates in this area for a really long time has been, isn't redistricting inherently political? And if it's inherently political, how can courts intervene and put brakes on that? What the court is basically saying to legislatures is you're free to take into account any number of different kinds of things that you do when you're drawing districts. You may care about the Constitution. You may care about the Voting Rights Act, as you should. You may care about keeping communities of interest together. The one thing you can't do when you're drawing a map is decide that you want to maximize one party's control, lock it in, and then prevent voters from voting your party out.
All right, Thomas Wolf in Washington. Thomas, thank you. Always good to see you.
Thanks for having me.